Thank you very much for that introduction, and good afternoon, ladies and gentlemen. Yes, I would like to present to you today the state of aims that we try to promote. And secondly, what kind of instruments should be used to take forward those policy aims once identified. To help us to answer those questions, we launched a consultation process in 2002 by publishing a green paper, which I'm sure that many of you have seen, putting these questions to the public, to mediators, to lawyers, interested parties, member states, as well as a number of other more technical issues that we also wanted some input on. We were very pleased to see the active debate that the green paper in fact created. There was a large interest from all interested parties. We got very constructive and very detailed replies to the questions we had put. And we also allowed us to build up a wealth of knowledge, I would say, on the state of mediation ADRs in Europe today. The question now is, of course, what conclusions have we drawn or are we about to draw? Well, from our side, we do believe that there is a case for having a policy in the first place on ADR at community level, based on the input we had on the green paper. In terms of the aims to define, we are still reflecting on this, but one of the main lines that we are thinking of in terms of policy aims would be to seek to promote dispute resolution methods in the community. One could formulate it in the sense that in a modern society, business, individuals, anyone who happens to encounter a dispute should have access to a wide range of different dispute resolution methods, allowing him or her or the company to choose what they see as most appropriate for their particular dispute. And mediation should be one of those methods. Something to stress there is perhaps that I deliberately leave out the word alternative dispute resolution. We are not so sure that that is the appropriate approach towards promoting mediation, for example. It is not necessarily an alternative to the justice system. It's a dispute resolution method in its own right. And as I said, the parties should be able to choose what suits them the best. We are also a little bit concerned about the use of the word alternative in the sense of that the main value of mediation would be to offload the court system. That is something we see quite often from, we saw it in fact in the replies to the green paper, that the main interest in promoting mediation, the main interest in having a policy on mediation would be that it could help to offload the court system. Also there we have some doubts. This could of course be beneficial, but again it tends to lead us away from that mediation is a useful dispute resolution method in itself, and is therefore valuable to support and to try to put on an equal footing with other older and perhaps more well-known dispute resolution methods. There are also certain specific issues that arise at the European level. We see this a little bit as part of ensuring access to justice. It's another way of saying what I just described. And that is something that has been stressed quite strongly by the European Council, for example, in its meeting 1999, where it stressed that individuals and business should not be discouraged or prevented from exercising their rights because of complexities or differences between the legal systems of the community. That involves in particular obstacles created by cross-border situations. So in other words, the overall aim should be that even though, for example, the parties are in different member states or the competent court is in a different member states, the access to justice should be equally easy as if all the factors had been in one and the same member state. And that reasoning and that aim we can also apply to the use of mediation. That the use of mediation should not be prevented or discouraged in a cross-border situation where the parties are from different member states, or perhaps when they wish to use a mediator from a third country because that suits them the best. And any obstacles created by that are things that we need to address. That also goes for the functioning of the internal market, which is of course perhaps the basis of what we do, both in terms of the users of mediation, who should have access to a dispute resolution method in the internal market, regardless of where they wish to conduct their business, but also, in fact, from the point of view of the mediators. the mediators, leaving aside court annex mediation and so on, but looking only at private mediators, are providers of a service, a commercial service. And so they are in fact operating in the internal market, which has as its aim to ensure the free movement of services. So a mediator who so wishes and who thinks he has the competence should be able to provide his service to act as a mediator in any member state of the European Union. And if there are obstacles to that, then it should be addressed by the Union also to ensure that we reach the aim of a well-functioning internal market. On the other hand, there are of course also things that we cannot do at European level because we are not competent for everything. There are issues of subsidiarity, things are better done at member state level. So when we look at the measures that we could take to reach these aims, we also have to make a difference between what must we do through legislation, where we do not have another option, and on the other hand, what are the issues that could be addressed through various instruments, legislation or otherwise. And as the speaker from UNCITRAL already mentioned, there are certain aspects of procedural laws that relate to mediation and where legislation is in fact the only option. And those issues are likely to be the main focus for us in developing a draft framework directive on mediation in the European Union. So the issues that we are considering to focus on will be questions such as the confidentiality, the interruption of limitation periods, enforcement of settlements, and to some extent also the promotion of the use of mediation as such, although that is something that we are more limited in what we can do. So what we are looking for is a compatibility between the procedural systems of the member states that allows for, let's say, a good functioning of judicial proceedings in relation to the good functioning of mediation. To a certain extent, that also requires a mutual trust between the member states, because it means accepting decisions, judgments delivered in other member states under other procedural systems, under their rules, and that these judgments and so on and agreements are recognized and not subject to any further scrutiny in other member states. So we also need to achieve a certain basic level of mutual trust between the member states in terms of mediation. So that is also the reason why we need to go into some extent the question of the quality of mediation services offered within the community. Things, on the other hand, that we do not see a need for legislation on for the moment is in particular that relating to the mediation process itself, the mediator himself or herself, i.e. questions of accreditation and so on. Those are issues where we have a choice. We could legislate or we could use other instruments. We could promote soft law or we could leave it to the markets. We are at this stage not convinced that legislation is the best option. This was undoubtedly the hottest topic we had in the Green Paper, in the replies to the Green Paper, and I think the discussion, in fact, still goes on. There are valid arguments on both sides, but we think in any case it would be premature to proceed with legislation on those issues at this stage. For the moment, we are in the stage of finalizing a proposal. Some of you may have seen that we had already a preliminary draft of this proposal for a directive available for public consultation. We received overall very positive and encouraging comments on that draft, also very constructive comments in the sense that it helped us to improve and address more in depth a number of quite difficult technical issues that are, let's say, hidden in many of the topics that we cover. We are seeking to take that into account now and see whether we can finalize this proposal in the autumn to have it formally presented by the Commission. And then will follow, as you know, the normal legislative process of the community where the Council and the European Parliament will have to decide on the adoption of that directive. Finally, just to wrap up, I think the heading for the theme of this panel was integrating deal-making into the justice system. With the somewhat fear of disappointing the organizers, I'm not sure we will do that. We won't go that far. But we will try to promote the compatibility of deal-making and in particular mediation with the justice system within the limits of what we can do. Thank you for your attention.